We are a grassroots organisation, a small organisation representing EU citizens and their family members living in the UK post-Brexit. And our work is quite diverse. It ranges from organising and mobilising EU citizens, communities, and bringing different groups of people together, to informing you and others about your rights, and holding the government to account through advocacy work on a policy level, and also through strategic litigation. This is the second webinar that we've hosted that seeks to explore some of the changes to the guidance around the EU settlement scheme. The first one was held back in August 2023 with Chris as well. Monique, my colleague, has just put a link to that webinar in the chat. There's a YouTube video of it. So if you missed that one and you want to go back and watch it, please click on that link. And both this one and that one seek to explore these changes that were brought into effect following a court case that took place at the beginning of last year, or the judgment was handed down at the beginning of last year. And I'm going to start by just telling you a little bit of the background to that case and what the changes are, before we then turn to the questions that you've got. And I know that you probably have many, which is obviously why you're here with us this evening. What I would ask is that you go ahead and put your questions in the Q&A. We can't guarantee that we'll be able to answer all of them orally, but my colleague Monique Hawkins is there, and she's going to be answering some of them in the Q&A function as well. And we'll field as many as we can to Chris. And I'm very grateful to those of you who've sent in your questions in advance as well. We've had quite a lot of questions come through. There are quite a range of issues that you're all seemingly very keen to understand more. And there are some key issues that people seem to be very concerned about, and where there's a real lack of clarity. And we share a lot of your concerns, and particularly the concern around the lack of clarity. So I know that we won't be able to answer everything, and you won't leave here with a perfectly clear picture of what the situation is under the EUSS now, but hopefully you'll have a little bit more of an idea than you did at the start of the evening. So just in terms of looking into the background a bit more, as I said, the changes that were introduced last month towards the end of May, and the changes that were introduced in the summer of 2023 came about because of a case which was brought against the government by the Independent Monitoring Authority, the IMA. The IMA is a monitoring body that was set up as part of the UK-EU withdrawal agreement, and its function is supposed to be to ensure that public bodies in the UK give effect to citizens' rights effectively and properly. And the IMA took the government to court. We also were involved in that case. We intervened, as did the European Commission, and the basis for it was that the IMA's view, which we also held, that the way that the UK government had implemented the EU settlement scheme wasn't lawful, and the key issue was that the way that the scheme was established enabled people with pre-settled status to suddenly find themselves without any status in the UK if they didn't apply to extend their status or apply to upgrade to settled status at the expiry of the status that they'd been granted. And the court agreed, and the court found that that wasn't lawful, it wasn't acceptable, and it wasn't in line with the withdrawal agreement for somebody to suddenly find themselves in the UK unlawfully, simply for having failed to put in a subsequent application. And so as a result of that judgment, these changes were introduced slowly, I would add. The first of those changes you will probably have been aware of included the introduction of an automatic extension by 2 years of people's pre-settled status, as well as automatic upgrades for those who are eligible to settled status. And alongside those changes, the Home Office also included introducing changes to the guidance regarding the way that late applications to the scheme were treated. And they also, in the same breath, got rid of the process of administrative review as a way for people to seek a remedy where they disagreed with the decision that was made by the Home Office. We put together a document with a lot of input from Chris that set out some of the questions that people had at the end of that installment of changes and at the end of the webinar that we held about it. And that is a document that is there on our website. I think Monique may have put it in the chat, or she's about to as well. So please go ahead and have a look at that Q&A document, which may also answer some questions that you might have. There we go. It's there in the chat now. So the 3 million, as I said earlier, was established to try and help protect the rights of EU citizens and their family members. And we're not the only ones, of course, that are doing that. There are lots of organisations out there, no doubt some of whom are represented on this call tonight, who are really working tirelessly to hold the government to account and to make sure that European citizens' rights are properly respected and given effect to. And we, along with lots of those other organisations, engage very regularly with the Home Office and with other governmental departments. We write to them often to set out our concerns. We meet with officials in meetings to try and influence the way that policies are given effect. We work very closely with we collaborate with the European delegation as well. And with several other organisations, and have done things like giving evidence to the Specialised Committee on Citizens' Rights, which is the meeting through which the European Commission and EU member states and the UK government are able to put on the table the concerns that continue to prevent people from being able to fully exercise their rights post-Brexit. And one of the reports that we've contributed to fairly recently was an all-party parliamentary group report on the links between migration and poverty. So it's not a report that's specific to the EUSS, but it's a really interesting read, and there's a link to it, which I think Monique is also going to put in the chat. So that's a little bit of the background before the changes that were introduced in May. Then on the 21st of May, the Home Office announced some further changes to the way the scheme was going to work. And there are 3 main changes that have been introduced. One of those is the change of the period of extension of pre-settled status from 2 years, the automatic extension being changed from 2 years to 5 years. No doubt that's one of the ones that has prompted many of you to join the call this evening. We'll definitely be looking more in detail into what that really means. And the second change that was announced was relating to what happens when somebody with pre-settled status goes on to use View and Prove. The change was that the expiry date that appears on the screen that employers, landlords and other checkers see when they use View and Prove will no longer show. It's a change that's actually now been brought in already from roughly last week, I think, possibly the week before now. Employers and landlords should no longer see a date of expiry on someone's status. But of course, there are still questions about what that really means. And we know for a fact that there have been problems as well, which maybe some of you will be asking about this evening as well. And then the third change, following on from that one that was announced, was that the landlords and employers who've already done an initial right to work check or a right to rent check will not be required to do any follow-on checks of those status holders once somebody has started the job or accepted a tenancy. And that's a change as well. And of course, these changes on the face of it are all very welcome. But as we all know, there's a lot that remains unresolved, and there are lots of things that have not been clearly set out. And so on that note, I'm going to turn to you, Chris, to to ask some of the questions that have been sent through to us in advance. I think we'll start with those ones, and then if any of you who are on the call have questions now, go ahead and start putting the questions in the Q&A. If you think of something as we go along, please go ahead. But first of all, I'll start with the question that we got from somebody called Jerome. I don't know if you're on the call, Jerome, but his question was whether or not the changes to the pre-settled status rules have changed already. And Jerome says, I'm a pre-settled status holder, so does that mean that my right to work in the UK is now going to be extended for 5 years? Do you think, Chris, you'd be able to give us a bit of a kind of broad explanation in answer to that?
Yeah, thanks very much, Kezia, and obviously thanks to the 3 million for inviting me along this evening. It's always it's a very interesting thing from my perspective, what I do working with the settlement scheme, to hear about the questions that people have about the information that the Home Office has given them about pre-settled status, particularly as this is the status which is most challenging for people to make sure that they can sort of exercise their rights. I think I just what I want to just start, because it's a good question to start with, because it sort of says how is there anything about pre-settled status changing because of these extensions that are applied automatically? And there's kind of two answers to that question. One is that obviously the fact that the Home Office is extending the pre-settled status, they said initially it was 2 years they were extending, and now they've announced it's going to be 5 years once they've made the changes. And the rights that come with pre-settled status, like for working, for obviously renting, for attending university, for healthcare, those rights stay. Like there's nothing about the fact that the extensions are being applied would change the rights that pre-settled status holders have. So that's a positive thing. So when you have pre-settled status, you're keeping the same rights. You're potentially going to get this automatic extension for 5 years once the Home Office implements that policy. But one thing it's really important to be clear about, and you alluded to this when you were talking about the IMA judgment, is that what the case that the IMA brought, which the Commission and the 3 million also intervened on, it wasn't to argue that the residence rules for pre-settled status are somehow wrong. It wasn't to argue that people should be allowed longer periods of time outside the UK. That wasn't what the case was about. The case was about whether people who had pre-settled status had to make a second application to be granted settled status. And that's what the court was making a decision on. So the court didn't say that the rules that apply to residency for pre-settled status holders are wrong. So nothing in that has changed. So we're probably going to talk a few times this evening about what it means if someone has broken their continuous residence. And as I say, like the court decision hasn't changed that. And the Home Office extension from 2 years to 5 years for pre-settled status also hasn't changed anything about the residency rules that pre-settled status holders need to abide by until they can qualify for settled status. Okay, oh, Kezia, I think you are muted.
I am, sorry. Yeah, I was just saying, absolutely. There's, I think, a lot of uncertainty about that, and I think this issue of continuous residence is something that's causing people a lot of confusion, and several of the questions that we've got touch on that as well. In fact, the second question does that as well. Second question we have is from Gabriella. She says my husband and I lost our pre-settled status due to having been away from the UK for over 2 years during the pandemic. She says, last week I came across an article about the changes which says pre-settled status will now lapse only after an absence of 5 years. So does that mean that now our pre-settled status is still valid? And if not, why not? So I think, yeah, this is a question that a lot of people have, is whether or not suddenly the amount of time that they can spend outside the UK has grown longer, has extended.
Yeah, Thanks. It's a very good question, and it has, unfortunately, has a complex answer. So, along with the announcement that pre-settled status will now be automatically extended for 5 years, the Home Office also changed a piece of legislation which says if you hold pre-settled status, then you would only lose this status automatically. They call it lapsing. That's the technical term that's used. So, but essentially it means you automatically lose your status if you are away from the UK for too long. The rule was if you're away for 2 years, the law has changed to now say if you have pre-settled status, you lose it after 5 years of being away. And the question that I have grappled with since that change in legislation is whether it affects people who have already been away for 2 years, so would have lost their pre-settled status under the way the law used to be written. I think when you look at the way the law has been drafted, it doesn't have a retrospective effect. So what I mean by that is it doesn't say if you lost your pre-settled status because you were away for 2 years, you can have it back because we're extending the allowance to 5 years. It just what the way the law is written, it says if you currently have pre-settled status, it doesn't use the word currently, but it talks in the present tense. It says if you have pre-settled status, you are now your absence period is 5 years before you lose it. But the implication from the way I read it is that you have to hold pre-settled status to benefit from it. So if you've already lost your pre-settled status because of being away for 2 years, then I don't think you can necessarily meet the requirement to hold pre-settled status when they changed the law. So that's my reading of it. Other people may read it differently, just to be clear. Like there's no court decision on this that we can point to understand it. So it's at the moment it's about how it's interpreted, but I read it in that way. So if people then say, well, that's unfair, isn't it? Because I shouldn't, some people now are going to be okay. They've got 5 years of allowance. I only was allowed 2 years and then I lost my status. And I can understand that point of view. The problem I can see with the argument is that once you have been away for 2 years, then you've broken your continuous residence. The withdrawal agreement doesn't permit people to be away for 2 years when they're in their pre-settled status phase. And so if you've lost your residency rights under the withdrawal agreement, it's quite difficult to argue that you should then have them reinstated because the Home Office has changed the law in this way, because the Home Office didn't change the law to benefit people who are no longer covered by the withdrawal agreement. They changed the law to benefit people who are still covered by the withdrawal agreement. It just so happens that the way they've worded the law is a little bit it's a bit broader than just the withdrawal agreement. So it's a really it's a complicated area, but my reading of it is that if you have already been away for 2 years before the law changed, and you had pre-settled status and you hadn't lived in the UK for 5 years with pre-settled status before you left, then you can't have the extension of 5 years.
Yeah, I mean, I think this is one of the issues, isn't it? That this is entirely uncharted territory. So we're all trying to figure out what the real consequences are of these changes for people, kind of in real time, because like you said, there's no court case on this, there's no precedent, it's all brand new territory. Yeah. So
I think if I could just add to that, and this is something that again people will probably say back to me, is like, if I go online, it looks like I still have pre-settled status. So you're telling me that my status has automatically been taken away, but my online account will show that I still have it. And that's a problem, because what you're seeing is something different from what your legal position might be, and that is a recipe for people to end up in difficult situations. So it's really it's really problematic that this area is problematic for people having the clarity that they're entitled to.
I wonder if it would be helpful at that point just to set out what sort of difficult situations people might find themselves in, you know, because I think there will be a lot of people in that boat, won't there, who won't qualify for settled status. I know we've had questions about this as well, because of a break in their continuous residence, but who, like you say, still have pre-settled status showing when they log onto the system, they're still able to work and so on. What sort of consequences do you envisage people finding themselves in?
Yeah, I think it's a very good good issue to discuss. Unfortunately, it probably has some quite like negative situations that we can think of. One thing I think it's important to be clear, because I know that in the Q&A, I've seen Monique's picked up a question and explained very clearly that the current rules under the settlement scheme is that if you have pre-settled status and you broke your continuous qualifying residence, so you are away from the UK for longer than you're allowed under the withdrawal agreement, which is not 2 years, it's actually, there's a 6-month residency rule with some limited exceptions under the withdrawal agreement. So we're not talking about absences of 2 years, we're talking sometimes of absences that just go over 6 months. They can break someone's residency. So if you've broken your residency and you have pre-settled status, then the rules of the scheme say that you cannot progress to settled status, because you can't build up a 5-year qualifying period. All residency periods under the settlement scheme, unless you're a joining family member, like a sponsored family member who joins at a later date, if you're not a joining family member, then your residency must begin by the end of December 2020. And if you then break your residency after that date, after the end of 2020, if you break your residency by being away for too long, then you cannot progress to settled status. But you might keep your pre-settled status because the Home Office hasn't yet realised that you have been away for too long, because the Home Office systems don't know how long you've been away for. They just so they would only find out if you applied for settled status and told them how long you've been away for. They would say, oh no, you can't have settled status, you broke your residency after the end of 2020. So at the moment, this is the issue. So people have pre-settled status, but they may not be able to progress to settled status. Now, I think one thing I would, again, we want to be clear about, we talked before we started the session, is that the Home Office policy on what to do with pre-settled status holders who have not got settled status yet is developing. It isn't decided. The Home Office has talked about potentially automatically upgrading people to settled status at some point in 2024. They've also said that their policy will be to remove pre-settled status from people who have been away from the UK for too long. But they're very broad policies at the moment. They don't have the detail that we need to understand to know when that might happen and how it might happen. And as anyone on this call, I'm sure, will realize, is that we may not have the same government that we have today in a few weeks' time. And so with different governments come different policies. And so I think we have to be clear, is that we can't say exactly how the Home Office will deal with people who may have broken their continuous residence, or who have definitely broken their continuous residence, because their policy isn't clear yet. They just say that, yes, we're going to look to try to remove the status, but how they do it, what they ask of people, whether they have any sort of they take into account different factors when they look at whether someone should lose their status, all of these things haven't been decided yet. So when we say to people, oh, your facts indicate you've broken your continuous residence, you cannot get settled status, we're talking about the way the rules are written today. So there may be other, a different approach down the line. So we don't want to sort of definitively tell people there's no hope, but we just have to base our kind of view on what we see under the rules today, and the Home Office stated intention to remove pre-settled status from people who have broken their residency. Sorry, I don't know if I gave you any specific examples then, but I was just trying to make a broader point about, if someone said to me, what should I do? I'm living here, I know I've broken my continuous residence. Am I going to get thrown out in the future? And the answer to that question is, well, you're not going to get thrown out, but your status, you may have your status taken away by the Home Office. but I don't know how that will look at the moment. So that, you know, as long as you have pre-settled status, you do have the right to carry on, as I've already said. Like all of those rights attached to it carry on for the time being.
Yeah, thanks, Chris. It's really a really important point to emphasize, I think. Andrea has just put in the chat an absence calculator that we have on our website, that if any of you are unsure whether or not you have spent too long outside the UK, please use that tool, which should help you figure that out. And so the next question that we've got, Chris, is from somebody called Ursula, and in fact you've sort of answered a lot of her question, I think, but I'm going to ask it anyway because I think it helps to put it into context to kind of situate the answer in response to a very specific question. So Ursula says that she's recently talked to the Citizens Advice Bureau and was told that the Home Office said that they'd be drowning in millions of applications. I think it's true, by the way, that we probably should not be called the 3 million, but more closer to the 6 million. But Ursula says, how will the Home Office track whether I've spent 180 days out of 360 outside the UK, or for any particular individual? And she says, I have dozens of flight tickets because I've had to go back to Germany several times. How will the Home Office actually know if I've left and re-entered the country? Is there a system in place to check that, particularly if I haven't had to go through any border controls? Similar questions were asked over email by other people, somebody called Marlene, and also somebody called Lida had asked a similar question specifically in relation to retired people who may not be in employment anymore. So how will the Home Office actually know if somebody spent time outside the UK, too much time outside the UK?
Yeah, so I think the answer in terms of is does the Home Office know? Does the Home Office know that me as a person, I've had, you know, 180 days outside the UK this year? I don't know because I don't work for the Home Office, but the Home Office does gather entry and exit data. Generally they use information that is provided by carriers. When we say carriers, we mean airlines, Eurostar, ferry companies. They provide information to the Home Office about who they bring and who they take away from the UK. So there is information. Like it's not that they have no clue. It's just that it's the issue with the data sometimes is it might not be completely accurate, or people may travel in on one document and leave on a different document, which would then screw up the data in terms of identifying that's the same person. So I think that it's very unlikely the Home Office has a very clear picture of someone's travel by looking at it, unless they looked very specifically. And I don't believe at this point in time that they would do that necessarily. However, if you are someone with pre-settled status, when you apply for settled status, you are asked about whether you've had more than 6 months outside the UK during your what's called your qualifying period, which is the 5 years of UK residency that you're relying on to get settled status. So you're asked the question, and of course, if you say no, yes, I have had more than 6 months outside, you're asked to explain that, because there are some exceptions to the 6-month rule. You can have a longer absence because of COVID or because of some other important reason, like associated with work or studying. So you're asked to give more information. And when you submit an application for settled status as a pre-settled status holder, you make a declaration, and it's about an honest declaration of, is this an accurate reflection of your residence in the UK? So those are the kind of ways that the Home Office processes and assesses someone's absence. It's like, in a sense, it is about a declaration of honesty on the applicant's part, because the Home Office has rules where if someone makes a dishonest declaration about their residency and that's established at a later date, then the Home Office can remove the status from them. So that's a consequence of making what they call sort of a false declaration. But ultimately, the simple answer is probably that there's not a clear idea of how much time people have spent outside the UK from the Home Office, although they could check records to potentially see someone's travel based on their identity document. But that doesn't mean that people should be going around saying, oh, you know, I've been living in the UK, when they haven't, because you're making a declaration of honesty when you apply for settled status.
Yeah.
So that's how the application process works.
Thanks. So Ursula had another question, actually. She said if she doesn't get the automatic extension of pre-settled status, what should she do? Should someone in that situation contact the EU Settlement Scheme Resolution Centre? And might there be technical errors that prevent some people from getting that automatic extension? What would stop someone having their status automatically extended?
Yeah. So in terms of, so again, it sort of ties into some of the other questions that kind of come up often about the extensions, which is, if I know that I've broken my continuous residence, is the Home Office going to give me an extension? Because they're going to say, well, you're not someone who's entitled to an extension. That shouldn't happen, because the Home Office is applying extensions automatically. They are not assessing whether people have broken their residence. There isn't a person who sort of hits the extension button. It's supposed to be done automatically. So there is no assessment of whether the person is entitled to the extension. The Home Office just gives it to you. That's their stated policy at the current time. Everyone gets it, and they should have it in the month before their current pre-settled status looks like it's going to expire. So if your status was coming up for expiry in July 24, then this month you should have received the automatic extension. So it should have happened. You should be notified by email. Your digital account should reflect that. Does it have? Are people slipping through the automatic extension net? Possibly. So I can talk from experience. I've come across it once. I know the 3 million has some experience as well. It should not happen. So just to be clear, based on what we understand from the Home Office, based on their policy, what's stated is it should not happen. Therefore, if it does happen, it's a glitch. We're talking about quite large data sets, so these technical things can go wrong. Should you inform the Settlement Resolution Centre? Yes, absolutely. That's the first port of call to communicate with them, because that's the Home Office, and someone should be on hand to help you fix that and get your extension applied. I think, Kezia, you also have, you'd like to hear about this because of the advocacy work you do as well. So I'm sure you're going to mention it, but there's obviously a tool that you have for people to raise these issues.
Yeah, absolutely. Thanks, Chris, for plugging that. We've got a report it function. We're really, really keen to hear about people's difficulties and problems with either with evidencing things through their digital status, using digital status, but also anything connected to the EUSS. And this sort of thing is exactly the kind of thing that we really need to hear about you from, so that we know what the problems are that persist, so that we can try and address them. The follow on from that is what should someone do if, unfortunately, their status has expired? And you've been very clear that shouldn't happen. It's a glitch. But what happens if someone does find themselves in that position? Does that mean that they genuinely don't have leave to remain in the UK, which obviously would be in breach of that IMA JR? But what should someone do? Should they leave the UK so that they don't become an overstayer?
Yeah.
What would you suggest?
Yes. So this is where the IMA judgment does apply to everyone. So if your status looks like it has gone beyond the expiry date, so it expired, you didn't get the automatic extension. Legally speaking, under the withdrawal agreement, your status hasn't expired, because under the withdrawal agreement, you have to be told if your status is being taken away. You have to be given the reasons. And so if it's just you passed the expiry date and nothing happened, that isn't a reason. You're not being told that your status has been removed. So legally, under the withdrawal agreement, it hasn't been removed. Okay, so that's your kind of legal position. That's great. But in terms of living your life, it's not going to be straightforward, because your digital account would appear to be expired. An employer, a landlord looking at that would also potentially see that expiry date, although because they're not supposed to see expiry dates, as Kezia talked about at the beginning, perhaps they wouldn't see that, and so it wouldn't affect you. But you would know that it looks like your state's expired. I could potentially create issues at the UK border as well, because that might be what your immigration records look like to a border force officer. So this is why we're talking about reporting it to the 3 million report, telling this settlement resolution center, because it should not happen, and it needs to be fixed so that you can continue with your pre-settled status. But legally speaking, no, it hasn't expired, because you cannot just lose your pre-settled status in that way under the withdrawal agreement. You must be told of a decision to take it away.
I think also worth pointing out that or asking you please also to report it to the Independent Monitoring Authority if you have this sort of problem, because they also, they've been set up as a body to have oversight of public authorities' implementation of the withdrawal agreement. That includes the Home Office's implementation of the withdrawal agreement. So maybe we can get that put in their link put in the chat as well. If not, just Google Independent Monitoring Authority, and there's a complaints button on their website, and it's through that complaints function that they gather information from citizens about the way in which the UK government might not be giving proper effect to the withdrawal agreement. And what Chris was just talking about is obviously a prime example of that. So actually, Chris, we've had several other questions come through in writing about this issue of whether or not there is retrospective effect in the extension enabling people who have already lost their pre-settled state or lost the ability to upgrade to settled status, whether those people would be able to suddenly find themselves back within scope for an upgrade. We had questions from Mohammed and Aitor about that. I think you've covered that, so I think I'm going to move on to one of the other questions that's a little bit more specific in terms of absences. This was a question sent through by Massimiliano, who's an Italian with pre-settled status. He says, I arrived in the UK in 2016, and I would like to ask if I can still upgrade from pre-settled to settled status when I've got about 10 to 11 months of absence for COVID reasons. And as a sort of sub question to that, what does COVID reasons really mean? Do they have to demonstrate that they couldn't come back into the UK, or is it enough to say that they didn't feel safe travelling because of the pandemic? So if somebody's got absences for COVID reasons and then absences of several months, 10 or 11 months for other reasons, are they still able to make an application? And do those absences need to be continuous, or is it a question of adding up all the little absences that somebody might have had?
Yeah, so in terms of whether someone can have like absences related to COVID and then an extended absences related to something else, I think the example given is studying overseas. So the answer is yes. The Home Office, in recognition that the COVID pandemic was obviously an unprecedented event, the Home Office did change the settlement scheme rules on absences. So before COVID, you would only have been allowed one extended absence, which goes up to 12 months, to do with studying or working overseas for a period, things like that. They're called important reasons. But because of COVID, the Home Office said, well, actually, lots of people are having extended absences related to the pandemic who may have already had an absence for another reason, like studying as well. So people should not be penalised, is the concept, because of COVID. So if someone has had an extended absence because of COVID, then that is acceptable under the rules of the scheme. The Home Office has written a policy in a way that differentiates between absences that go up to 12 months and absences that go beyond 12 months. So what they basically say is up to 12 months outside because of COVID can be for any reason. If you felt like being somewhere that wasn't the UK, that's fine. That's not a problem. You state that in your application. If you went online because of university, explain that in your application. So up to 12 months is almost always acceptable. If you go over 12 months because of COVID, and many people did, then the policy the Home Office has asks you for a bit more justification. Like, were you being told not to come back? Were you, by your employer, your university? Was there family issues that really kept you outside? So if you have gone over 12 months absence, you may have to do a little bit more explaining to do with the COVID absence, but the policy is supposed to cover you. If you genuinely sort of weren't able to come back to the UK because of COVID. So that covers COVID. And then, as I've said, the what was the normal absence rules that applied if COVID had never happened is about absences to do with studying overseas, to do with a work placement, and you're allowed up to a year for those. So you can't go beyond 12 months for something that's not related to COVID. But you can, like I say, you can have a COVID absence and you can have an absence for study or work or for another important reason and still complete a qualifying period for settled status. And just on the last point was, do they have to be like what people often ask me is, do they have to be like single absences? So if I was away because of COVID for 12 months, does that have to be continuous? Or if I was away studying, for up to 12 months, would that have to be one absence? The answer is the rules are written as a single. So it is written as a single absence. So the concept of these extended absences is that they are one block of time. So someone traveling in and out the UK every week or like every few weeks, but also studying overseas, in theory, is not meeting what the rules say, because that's not one absence, that's lots of little absences. Personally, it might be a concept that's worth testing a little bit in terms of if it's a lead kind of, because if you wanted to come back, if you were studying overseas and wanted to see your family every few weeks, is that different from someone who's studying overseas who not necessarily didn't want to see their family but didn't feel the need to come back every few weeks? Is your situation that much different? So I think this idea of like one single absence is something that should potentially be a bit more flexible than the way that the rules are written. But if you look at the way the rules are written, it is, when you have an extended absence, you are not supposed to have lots of little absences that build up to over 6 months. It's supposed to be, you started it, you finished it 10 months later when you were studying at an overseas university, and then you came back. So it's a little bit unclear, that part about if you've come back during the period when you are sort of outside for your extended absence, what that will do to a continuous residence period.
So another part of Massimiliano's question, which I know is something that lots of you are asking in the chat as well, is about whether or not people can use the extension of 5 years or even the 2 years as a way of building up their continuous residence. So if there was a gap earlier on, can people now use the additional years that they've been granted pre-settled status for to make good on that error?
Not if the continuous residence was broken after the end of 2020, then the extension doesn't help you to get the settled status unless you are a joining family member. So, but that's a smaller group of people. So if you were someone who was resident before the end of 2020, and then you went away for an extended period that broke your continuous residence. So not those examples that I just gave, because they are acceptable reasons to have extended absences. So you were away for too long, but it's not something you can justify. You have broken your continuous residence, and you come back after the end of 2020. The extension doesn't help you because you cannot start a new qualifying period. You cannot start another 5 years of residency from 2021, 22, 23 onwards. The rules aren't written that way. It's the withdrawal agreement creates a cliff edge on the 31st of December 2020. If your residence period starts before then, if you break it after that date, then you cannot start another qualifying period of 5 years, even though the Home Office is giving extensions for 5 years. They're not giving it to people for the purpose of starting new qualifying periods. They're giving it to people so that their pre-settled status doesn't expire, because that's what the court told the Home Office to do. They said it cannot expire, but the court didn't tell the Home Office you need to let people start new qualifying periods after the end of 2020, because the withdrawal agreement doesn't say that.
Thanks. Hopefully that answers that provides a bit of clarity for some of you who've been asking questions in the Q&A. A slightly different question that's in the Q&A from Faisal is a question about extended family members. If somebody's here as an extended family member with pre-settled status, what will happen to that family member and their application for settled status if for some reason their sponsor has had to leave the UK before the family member's 5 years is up?
Yes, I saw that question. I thought, wow, that's a complicated question. So the answer is, I mean, it doesn't have, so just remove the word extended family member, because it could apply to any family member. It doesn't, it's no different for family member from extended family member. So if you are a sponsored family member or sponsored extended family member, you are dependent on that sponsorship. Like, that's the idea, is that you come to the UK to live with your sponsor. So if your sponsor then leaves the UK, that can have a very significant impact on your pre-settled status. If you've already qualified for settled status, you're fine, because you've got settled status in your own right. You don't need sponsorship from a family member once you get to settled status. But if you're in your pre-settled status period of 5 years, then you do need to have that family sponsorship. But there are some exceptions to that rule. So the general rule, I'd say, is that your family member who sponsored you needs to be in the UK at the same time as you're building up your 5 years. That's the general approach. That's how I'd start looking at a situation. However, there are some quite limited situations where your sponsor may be able to leave the UK and you can carry on building up your residency for settled status. But we're talking about limited situations here. And so if this is what's affected, if this is the situation you found yourself in, Faisal, then you really need to talk to an EUSS expert, because a settlement scheme expert, because they need to identify whether you fall under any of the categories where your pre-settled status is not affected. Because obviously, if you've lost your sponsor and you're on pre-settled status and you're not going to qualify for settled status, then you need to think about what does that mean for me in the long term, on the assumption that the Home Office might at some point approach you about saying, well, you don't qualify under the scheme anymore. So but you need to speak to someone to find out if you can still carry on and qualify for settled status, because sometimes it's possible. But generally speaking, if you lose your sponsor, but because they've left the UK, that can have a very negative impact on qualifying for settled status.
So Faisal had a follow-on question, actually, which may well be too complicated to answer here and now. But if say that sponsor did leave the UK, but then came back having broken their own continuous residence, but that person then is themselves, the sponsor is granted the 2-year extension, or now maybe 5-year extension, even though their own continuous residence has been broken. If the family member in the meantime builds up their own 5 years, what do you think would happen then to the family member's ability to apply for settlement?
So the general rule, probably the simplest way to think about it is a family member, a sponsored family member, can never overtake the person who's sponsoring them, which will almost always be a European national. So if you have a European national who has got an extension of pre-settled status, the family member cannot go to settled status before that European national gets the settled status, because the scheme doesn't work like it allows the family member can follow on to get settled status once their sponsor does. In the most normal situations, I'm not, like I say, there are some limited situations where that doesn't apply, but the general rule I'm talking about. So if this person in this example, because we know that the European national will have broken their continuous residence and cannot qualify for settled status under the current rules, ultimately, it doesn't matter if their family member has completed 5 years, because they can't overtake their sponsor and get settled status, because the sponsor isn't going to get settled status themselves. That's how it would work.
Thanks. In a moment, I'm going to switch and ask a few questions that relate to the way that people can actually give effect to their rights rather than the issue of absences. But Stephanie has put a question in the Q&A. Hi, Stephanie. About kind of broadly, what is it that would make somebody automatically eligible for an upgrade to settled status, perhaps especially an automatic upgrade?
Yeah, okay. So something to be clear about with the intention to automatically upgrade people to settled status is there's no difference on the rules that apply to people. So only people who've got a 5-year qualifying period can upgrade to settled status, either automatically or by making an application to the Home Office. But so the intention of the Home Office to automatically move people to settled status is that's because they say, well, this person's completed 5 years. We can see this based on the records, the government records we can access. So why bother making them apply for it? Because we can see that they qualify. So let's just move them. It saves everyone a lot of hassle. They don't have to apply. We know that person's entitled to settled status. So basically, that's what the idea of automation is for settled status upgrades, is to move people to the correct status. But the only way the Home Office will know this is by doing it for an automatic upgrade is by looking at their own data that they have on people. So when you apply at the moment, if you have a national insurance number, you give the national insurance number. The Home Office checks the national insurance number. They checks it against HMRC for tax records, against the Department of Work and Pensions for some benefit information. So that's what they do at the moment. So the automation process is that same approach. It's just that the Home Office does it. If they have your national insurance number and you have pre-settled status, then they'll just run the check automatically. That's how I understand the approach to be. So it's only going to work for people basically who have like tax or benefit records that show them living in the UK for 5 years continuously. So if you got pre-settled status and you worked for 3 years and then you've had a career break for the last 2 years and haven't made any national insurance contributions, you are not going to be automatically upgraded to settled status, because all the Home Office will ever see is the 3 years that you were working. They won't know anything about the other 2 years because you didn't make any national insurance contributions. So you still have 5 years of residence. You're still entitled to settled status, but you're not going to get an automatic grant from the Home Office because their information isn't good enough to see that you've been here for 5 years.
Thanks. Okay, so Chris, I'm going to turn now to a couple of other questions that were sent through in advance. We've got one from Marion, which is regarding the view on the display rather on View Improve. Marion says the Home Office has promised not to display and disclose one's status to employers and landlords in the future. When will that come into effect? And if someone has lost their status, would employers and landlords be able to see that or not? And if they are in that situation and they lose their status, will banks be able to tell?
So in terms of the changes being made, I'm going to very much rely on Monique, a colleague from the 3 Million, who's behind the scenes working tirelessly to answer questions, who has informed me, so I haven't seen it, but has said, yes, the checks for employers and landlords, they no longer see the pre-sale status expiry date doesn't show to them. They don't see anything to do with that. So I think that it's worked. It's been changed for employers and landlords. I think there might be a question about whether some other people who check it are seeing the same thing as employers and landlords. So I think there's still a little bit of uncertainty about the other people who make immigration checks, like banks, but definitely employers and landlords don't seem to be seeing it.
I think what it is actually, if I can just jump in, is that what we're seeing is that the third type of checker, who's anyone that's not a landlord or an employer, doesn't see the expiry date, but they do still see that somebody has pre-settled status, which isn't something that landlords and employers see.
Can I just jump in and say we've requested that the Home Office change that so that it just says status under the EU settlement scheme, and we got the answer, they'll take that away. So no answers, but that is what we're asking, because we feel it should simply say that it's EU settlement scheme status rather than indicating that it's limited in any way.
But thanks, Monique. I think and just for anyone who wasn't sure, that reinforces why we need to hear your experiences about digital status, so that, because I don't, this kind of nuance of what's being seen by checkers would not have been, wouldn't have known about it if it hadn't been for people asking and reporting these things. And so it's really, really crucial, so that actually these commitments and promises being made by the government are doing what they're intended to do, which is to remove that doubt about what pre-settled status is for people checking immigration status. To answer the second part of the question about what would happen if what would an employee see, or a landlord or anyone checking, if the status is removed, I think it was, if we are talking about your status has been taken away from you, so pre-settled status or indeed settled status, because there are some circumstances that can be taken away. If you are told by the Home Office, we have removed your status, if they do that, you're allowed to appeal that decision. You can argue that it's the wrong decision, but if you went through an appeal and it was still confirmed as the correct decision, so if you have had your status taken away by a decision that you're informed about, then that should be reflected in the digital profile, your UKVI account. It should change to say to effectively say you no longer have status, because the decision has been taken to remove it. So obviously the intention is so that you wouldn't be able to use rights attached to that status, right to work, etc., because you don't have the status anymore. So an employer, you shouldn't be able to generate a share code if you had your status actively removed. So you wouldn't be able to pass the check from the employer or the landlord, because you can't use the tool that you need to do that, which is by using a share code.
Thanks. A different question come in from Paolo, who is asking whether or not pre-settled status holders have the right to have the right to buy property, or only the right to rent. And he's saying, has anything changed on that front, or in order to buy a property, do I have to have settled status?
So from a legal point of view, there's no difference between pre-settled or settled status. I mean, incidentally, you don't have to have UK immigration status to buy property in the UK. You can buy it as long as you don't, because if you're not living here, you can still buy property. So there is no difference between pre-settled status and settled status in terms of the ability to buy property. Sometimes there might be an impact if you're looking to borrow money on the difference between pre-settled and settled status, because money lenders will do a risk assessment, and that part of that risk assessment may be to do with someone's immigration status. So it's possible that that's what the question related to, rather than yeah. So no, if someone is saying to you, you cannot buy property because legally you need settled status, not pre-settled status, that's legally that's not correct.
It may well relate more to mortgage rates, because we've definitely heard several people reporting that they were not offered favourable mortgage rates, for example, because of the insecurity of their status as a pre-settled status holder. So it might well be, it might well have related to that. And there's actually a follow-on question from someone called Violet, which is whether or not somebody who's been here for, say, 4 years with pre-settled status and is getting quite close to the point at which they would be eligible for an upgrade to settled, if their circumstances mean that they now need to leave the UK for any reason, what can they do to maintain their residence? And would something like buying a property in the UK help them in any way to maintain that status?
Yeah, so I'll answer the question in reverse. So if you're not physically present in the UK, then you're not. Then nothing that you do with buying property or attaching yourself to documents which give you a UK address, it doesn't change anything from the perspective of the settlement scheme, because you're not physically here. the settlement scheme is about physical presence in the UK. You need to have 5 years of physical continuous residence to get settled status. So in the sense of like showing that, you know, buying property to show some ties to the UK doesn't cut it if you're not here, because it's about your physical presence here. The year 5 of the qualifying is a kind of interesting is an interesting year, because the same rules apply. But if you have gone through years 1 to 4 and you've always been here for more than 6 months in each of those qualifying years, then you've got your 4 years of continuous residence. And if something happens which said, okay, year 5, I now need to spend time outside the UK for, you know, a reason that's important, not just because you choose to, but something that actually is affected your life, you can use I've talked about the exceptions to the 6-month rule, so extended absences, as we probably usually refer to them. So you could have your extended absence in year 5 if it's an important reason that you need to go overseas in year 5 and you haven't done that before in any of the other 4 years, then you can use your allowance in year 5. There's no reason to there's no difference if it happens in year 5. What happens in year 5 is that once you cross the year 5 line and you've got a 5-year continuous period, then you don't have to come back to the UK because you've qualified. You've hit the 5 years. So once you hit the 5 years of continuous residence, what happens after that is you get the extended allowance of up to 5 years before you'd lose settled status. You'd have to apply, obviously, to get settled status at the moment. But you could say years 1 to 4, I was here at least 6 months in each of the 12 months. Year 5, family emergency overseas. I left in like month number 1 of year 5, and the rest of the 11 months I was outside the UK with my family because there was an emergency. That's a 5-year continuous qualifying period. You cross the line. You don't have to come back to say, oh, I came back within the 12 months, because you already crossed the 5-year line. So that's the difference with having an extended absence in year 5, is that once you cross the line, you don't actually have to come back. If you have your extended absence in year 1, 2, 3, and 4, you have to come back to carry on that building up your continuous residence. I hope that makes sense. It's not a straightforward concept, I do understand, but that's the rules are no different. It's just that the impact doing it in year 5 means that sometimes people don't have to come back up within 12 months because they've already completed the qualifying period.
I think something that a lot of people are maybe still not clear about is when this extension of pre-settled status is going to take effect. So I suppose there are 2 parts to that question. Some people have asked about it in the Q&A, about when the change is going to be made so that someone will be given 5 years rather than 2 years additional pre-settled status. When's that going to actually take effect? Yeah, maybe I'll ask that first.
Yeah, I don't know. I wish I did. But no, so the Home Office, they've sort of indicated it will happen as sort of soonish, but they didn't give a time frame. They said with the checks, the immigration checks that we were talking about for landlords, they said we'll do that fairly quickly. They didn't give the same commitment for the 5-year extension, so can't give a specific. The last extensions that I saw, which came to me last week, were still for 2 years. So as far as I'm aware, it hasn't yet happened. So yeah, we would.
And we don't know yet, do we, what will happen to those people who've got the 2 years when the 5 years comes into play? You know, will those 2 people be granted an extra 3 years or not?
Yeah, no, exactly. It's a good question. Don't know. Again, we're trying to sort of always think, or my job is always thinking in what does the judgment require the Home Office to do? And there's nothing I can see in the judgment that would force the Home Office to give people with 2-year extensions and that extra 3 years to get them to 5 years. Although maybe you could say, well, if they felt a need to change it from 2 years to 5 years, if they felt that was the way that they should be implementing the judgment, then I guess you could say, well, that applies to everyone, including those who've already got the 2 years. But it may be that the judgment doesn't force them to apply it in a retrospective way. But we'd like to try and get some clarity on that question.
Yeah, absolutely. And I know this, at the risk of sounding a bit repetitive, I think it would be really helpful, Chris, if you could just tell us again briefly how long, like in summary, how long can someone be absent? Because there seems to have been, I think Monique might have answered some of the questions that were in the Q&A on this now, but I think it's useful again to have a recap for everyone, to hear how long you can have as a continuous absence or an absence, because there's been talk about 6 months, there's been talk about 2 years absence. Now people are saying, can I be away for 5 years? So just as a sort of headline, what would you say to people?
So what the way I think is most straightforward to think about it is to say, like, I moved to the UK on date X, like let's say the 1st of January 2020. But so if that's the date you move to the UK, then you need to look 5 years ahead and say, those 5 years from when I moved to the UK to when I completed a qualifying period for settled status, I have to have maintained my continuous residence. That's the terminology that we lawyers will use. Continuous residence. It has to apply for 5 years. In the vast majority of cases, there's a few limited exceptions, but really for the majority of people, I started at the beginning of 2020. I need to be resident continuously for 5 years. The rules within those 5 years are that you should be at least 6 months in the UK in each 12-month period, with the limited exceptions that I talked about due to COVID or an important other reason, maybe you've been studying overseas. So within those 5 years, you can have an extended absence, you can potentially have 2 extended absences, but everything else has to be resident for 6 months in each 12 months. So if you've done that, then you complete a 5-year qualifying period, you are entitled to get settled status. As long as you can prove it to the Home Office, you get settled status. Once you've got those 5 years of qualifying, after that, you can have an absence of up to 5 years before you would lose any status that you're granted. So if someone says, I was here for 3 years and then I left for another 3 years, but I've been given an extension, so can I come back and complete another 2 years? No, is the answer, because you had your first 3 years, you broke your residence by being away for more than 2 years. Even if you kept your pre-settled status, you broke your residency. And then so coming back and then doing the last 2 years doesn't give you a 5-year qualifying period, because it didn't happen as a sequence. It's not cumulative. Like you cannot put together 2 periods if you broke your residency after 2020. So that's, I'm sorry, even when I say it, I recognize it's not straightforward. But like I say, I think the way that people need to assess it is, where is my 5-year continuous residence period? Did I have a break in that period of 5 years that was too long? And if I did have a break that was too long, it's going to stop me getting for settled status under the current rules, even if I get an extension. Even if the rules change on how long I can have outside with pre-settled status, I still can't get to settled status.
The exception to that, though, would be if somebody actually came back after an extended absence, but still before the 31st of December 2020, wouldn't it?
Yes.
So,
correct. Yes.
So if somebody got their pre-settled status in 2019 and then left the UK and had a break in their continuity of residence, but came back before the 31st of December 2020, yep, would they have problems getting settled status, or would they be all right?
Yeah, so if as long as you can show a 5-year continuous residence period that began by the end of 2020, you can progress to settled status. So you, in Kezia's very good example, you've had a full start. You thought you were starting in 2019. You even got your pre-settled status lined up so that you could start, but you had an absence that was too long. You broke your continuous residence, but you did come back before the 31st of December 2020. So all that happens to you in that scenario is the bit that came before in 2019, you just can't use that, but you start again in 2020 when you came back, and then you can build up your 5 years. So if you had a really long break from before the end of 2020, but you were back in the UK by the end of 2020, you can still qualify for settled status. And if you need to use the extensions that the Home Office has given you for pre-settled status, that's fine as well. You can use the extensions to build up your 5 years.
Yeah, that date is an important one to have in mind, I think, isn't it? Except for joining family members, like you said earlier, which we're kind of staying away from. But if you're a joining family member coming into the UK, the 31st of December 2020 doesn't apply. Is it worth perhaps Chris just saying a little bit more about that?
Yeah, so joining family members, I mean, they are actually, I mean, even family members who were resident by the end of 2020, if they break their continuous residence, they can start again as joining family members. But if you have a family member, so if you got married before the end of 2020, you're living here, you're European, you're building up your 5 years that started before the end of 2020, but your spouse is overseas at the end of 2020 and they were only able to join you in 2022, that's fine. It doesn't matter that it was after 2020 because they're a sponsored family member. They can start their qualifying period in 2022. There's absolutely no problems. And joining family members also have an advantage in that if they start a qualifying period and then they break it, they can start another qualifying period as long as you're still sponsoring them, because I don't mean this will sound slightly strange, but the right belongs to you rather than your family member. The right that someone who's European and lived in the UK by the end of 2020, your right is to have your family members with you, the eligible family members. And so if one of your family members comes and joins you, but they have to go away again for a long period, you still have the right for them to come back and join you at a later date because they're still your family member, and you keep your right for life to have your family members with you. So joining family members just essentially have a different set of rules when it comes to starting the qualifying period. Family members still have to do the 5 years to get settled status, but if they break their residence, they can start another period of 5 years at another time if you're still sponsoring them.
Thanks. Thank you so much, Chris. I'm conscious that we're 15 minutes away from the end of the webinar now, so I think that we'll have to stop with questions there. But thank you so much for providing all of that that insight into what is really, sounds on the face of it like a straightforward set of rules, and as we see, really is couldn't be further from that. I'm conscious that many of you have asked questions that we haven't been able to answer in full, although I know that Monique has answered an incredible number of them, which is great. But please do get in touch with us if you have questions that go beyond what we've addressed here. Our email address, I think, is in the chat already, info@the3million.org.uk. We know that there are lots of questions that we haven't been able to answer, and that we've got these questions ourselves as well. There are lots of immigration lawyers out there and people working in this sector who are as baffled by some of these questions as you are. So we just want to take you through a few other updates now about the work that we're doing. I think Andrea is going to come on and talk to you as well. There she is.
Thank you, Kezia. Hi, everyone. I just wanted to also thank you for joining us tonight, and we hope you've found this Q&A session useful. As you know, all of our campaigning and advocacy is actually based on the issues that you bring up with us. So we want to take this opportunity to ask you to please use our reported tool to let us know about the problems that you are facing. So whether it's waiting for a long period of time for a decision from the Home Office, or if you have been unjustly refused, or if you face difficulties proving your status through Proof, please do report it at the3million.org.uk/report-it. If you are an immigration advisor and you would like to go more in depth in how to address these complex legal and practical issues with the EU settlement scheme, then we really encourage you to join the ILPA training that's coming up on the 3rd of July. And you can find links to those in the chat.
Yes, very useful resource, ILPA. It's the Immigration Law Practitioners Association. We'd also like to take a few moments just to update you on some of the other things that we've been involved in. If you follow us on and read our newsletters, you'll be aware of this already, but over the last few months, we've been raising money through a crowd justice fundraising campaign for intervention fighting, an intervention fighting fund. We've been able, with the money that we raised through that, and also with help from ILPA, we've been able to intervene in a series of cases where EU citizens have been denied access to welfare support. More than 260 individuals have contributed to that fund, which has enabled us to do that. And we've already been successful in 2 of those legal interventions. But we really need help. We need your help to continue to be able to intervene in these cases. They can have very positive impacts for the individuals whose cases they are, and the higher up through the courts we go, the more chance there is that there will be a legal precedent set, which means that many more people will be affected and hopefully able to access welfare support. At the 3 million, we believe that no matter where we were born or the colour of our skin, what we earn, we all deserve to live in dignity and in the country that we call home. But as we all know, this government has pushed a lot of people, many of our friends, our relatives, our colleagues, into destitution by, we say, unfairly denying them help and access to welfare support when it's really needed. So there will be people waking up tomorrow really struggling to know how to put money, to put food on the table, to find the money to put food on the table and pay their bills. But we don't think it has to be this way, because we think that there are legal arguments that can be made that means that everyone with status under the EU settlement scheme should have access to welfare support and benefits on the same footing as British citizens and as people with settled status have. Now, it's quite a complex thing that we're still struggling also to really wrap our heads around. The courts are grappling with it. As we've said, it's all unprecedented territory in many ways. But the government considers that there are some people who are part of what we call the true cohort of EUSS beneficiaries, and others are part of the extra cohort. So the true cohort are the ones that the government say are people that the withdrawal agreement set out to protect, who had been exercising treaty rights before the end of 2020 and who have to have their rights protected. But because of the way the settlement scheme was implemented, all someone applying has to do is show that they were resident in the UK, not exercising those treaty rights. And that group are the group that the government calls this extra cohort, which they're being more generous towards in giving status under the scheme too. But the problem is that the government doesn't tell anyone whether they're deemed to be part of the true cohort or the extra cohort, and it's really problematic, because it means that thousands of really vulnerable people end up falling into destitution, because it's only at the point that they apply for something like universal credit or homelessness assistance that they find out that the government sees them as part of this extra cohort, and they then have to go through additional hurdles. There's a lot of evidence that they have to provide to try to persuade decision makers that they're actually part of the true cohort. And we just don't think that that's right. And we don't think it's what the withdrawal agreement says ought to happen either. With our interventions in these legal cases, we're trying to get rid of that problematic distinction. We think it will be more straightforward for the government as well if that distinction wasn't there. And we've already been able to secure positive changes for individuals, but we really want to set a precedent, like I already said. One of the cases that we'd intervened in recently is a case called Hynek against Islington Council. This was someone who was working as a software engineer until May 2020, and then because of the pandemic, he found it difficult to find subsequent work. In 2021, he applied for homelessness assistance and found himself sort of sofa surfing and occasionally sleeping rough. But he was refused support by the council because he didn't pass what the Home Office and the government and DWP call the right to reside test. So having pre-settled status alone wasn't enough for him to be eligible for homelessness support. And in that case, in Hynek, the judge agreed with us that pre-settled status holders do enjoy or should enjoy the same rights and protections set out in the withdrawal agreement. And one of those protected rights is the right to equal treatment. And so we really want to be able to take this to the higher courts and to push this legal argument in other courts as well, to help other people like Mr. Hynek, because we really believe that that interpretation should apply to welfare support assessments, including applications for universal credit and housing benefit, as well as homelessness support. So if you are able to donate to our crowd justice campaign, please do. I think somebody's going to put it in the chat, or maybe already has. It's really, really, really vital. And because we're a small organisation, we don't have the funding to do this otherwise. We have a fantastic team of lawyers that represent us and put these arguments so succinctly and so clearly for us. They do a lot of the work that they do for free, pro bono, but there's a limit to that, and these cases require a lot of work, and we desperately need to be able to pull together a fund to enable us to continue with these legal arguments. So please do donate if possible, and spread the word as well.
And finally, last but not least, we are in the midst of a general election campaign. So I'd like to remind you all to reach out to your friends and loved ones who have the right to vote and ask them to do so on the 4th of July. But members of parliament have a duty to represent everyone in their constituency, whether we have the right to vote in general elections or not. So this means that right now we have an opportunity to put the issues that affect our communities on the agenda. So I urge you to write to your local parliamentary candidates, share the issues that you care most about, and ask them what they will do for EU citizens in the area. So you can use the template that you can find in the chat to write to your parliamentary candidates. In our EU Citizens Campaigns network, formed of community leaders from across the UK, we've put together an EU Citizens Manifesto for Change, and this is the result of over 50 sessions of listening with groups of EU citizens and family members, and spreading these policy asks to candidates will really put us in a great position to start building connections with new MPs. So you can find our manifesto for change in the chat as well. And if you would like to meet up with others in person and connect over our shared ideas for the future, we invite you to join us in London next week. On Tuesday from 5 p.m. We'll be at St. Margaret's House together with friends from other organizations in the migrant sector, including the Migrant Democracy Project, JCWI, We Belong, Migrants Organized, and Pomoj. We are organizing a migrants hustings where we want to imagine a really bold vision for the future, what policies you would put in place for our communities, for our friends and our families. We're going to have creative, facilitated conversations, arts and crafts and zine making, and we're going to bring to life this vision for a really fairer world for migrants, racialized communities, and workers. We'll be joined by parliamentary candidates from different political parties at the hustings, but they're there to be our keynote listeners and to learn from our experiences and share what they pledge to put in place for our communities if they are elected. So at the 3 million, we are preparing for a new government, and in September, on the 9th of September, we're going to be organizing an EU Citizen Summit in London, where hundreds of EU citizens will come together holding new decision makers to account. So we really hope that as many of you as possible will be able to join us and get involved, asking members of parliament to make pledges for our communities. You're going to find the links to all of these events on our social media and on our newsletter. And we're also going to send you a follow-up email tomorrow with the recording from today, with a comprehensive FAQ that we've already published on our website, and further information. But please don't hesitate to get in touch with us if you have any further questions. And I would like to say a big thank you to Crispin from Seraphos, who has been taking your questions tonight, and to Kizia as well. Thank you again for your support for the 3 million and for joining us tonight.
Thanks. Good night, everyone. Thanks, Chris. Bye.